For those of you who don't know, Impact.tech is a 50 years seminar series. We do those deep dive into an area of technology that we think is extremely promising when it comes to its potential to solving big unsolved problems in the world. And we're trying to kind of map different areas of science and technology and see, what is missing, what can be commercialized, and how does that happen. Recently, we decided that in addition to those kind of what seminars, we want to add the how seminars, which is, when you already know what you're doing, how do you do it? And there's many common themes, right? And when you think of many deep tech companies and people thinking about commercializing, and also for the investors among you, for people assessing and investing in deep tech startups, IP is one of those themes, right? So we are going to actually have more seminars in more kind of how seminars. So we're quite excited about that, because we also think this is going to continue to add value to the founder community, the investor community. We're actually right now developing a seminar on scientific literacy for investors, obviously trying to finally get there. But hoping it will be really, really exciting for founders and future founders out there as well. So
so this is about IP. Understanding the intricacies of intellectual property is obviously really important for both innovators and investors. We at 50 Years fundamentally believe that deep tech companies win by out-innovating the competition and building the best products. But they often rely on IP strategies along the way, be they preventive or protective. And despite this, though, there's a pretty big knowledge gap we've noticed between founders, investors, and legal strategists. And the goal of this seminar is to try and lessen that gap. So this seminar is an introductory guide to the world of IP applications and strategies, ranging from outlines of the basic types of protection to specific offensive and defensive case studies. So it's going to outline a step-by-step process of filing, applying legal tactics, and maximizing outcomes when doing things like licensing or doing acquisitions. So the world of IP can feel a bit overwhelming. Patents, trade secrets, provisionals, NDAs, PCTs, FTOs, and I'm already exhausted. But we're lucky to have some incredible IP experts to guide us through all this and more today. So this seminar is going to be led by Stern Kessler's directors of Electronics Practice Group, Michelle Hollebeck and Don Featherstone, as well as the director of the Biotechnology and Chemical Practice Group, Gaby Longsworth. Stern Kessler, for those that don't know, is an IP law firm that's been around for over 40 years. And focuses entirely on IP strategy and defense. So I'm going to run through quick bios of each of the speakers. So Michelle, who's going to be speaking most, specializes in software, digital health, bioinformatics, and optical tech, with a particular focus at the intersection of optical devices, big data, and the life sciences. She's developed hundreds of tech and business portfolios, ranging from startups to Fortune 100s. Don focuses on some sectors near and dear to our heart, like climate tech, computer systems, architecture, photo, lithography, digital circuits, user interfaces, and he leads the firm's nanotech industry team. He also has experience with helping companies across a bunch of different sizes. His niche areas of expertise include strategic patent portfolio creation and management, PTO litigation, and reexamination. And Don, I'm hoping that we'll learn exactly what reexamination is. I don't even know what that is, to be totally honest.
I'm not sure we're going to get that far today, Seth.
All right. And finally, Gaby practices primarily in the fields of biotherapeutics, small molecules, biologics, immunotherapy, antibody tech, microbiome-based tech, synthetic biology, and DNA amplification, PCR, all that good jazz. Diagnostics and vaccines. Super exciting stuff. She manages IP portfolios and has managed over 1,000 different patentability options in the biopharmaceutical space. Deep expertise there. So as you can see, we have some incredible experts and expertise among all of them. I'm really grateful that they've offered to share some of their expertise with all of us. And so with that, Michelle, do you want to take it away?
Sure. First question, can you hear me?
Yes.
Excellent. So we're good so far. Well, thanks for that introduction. And we are really grateful that you've given us the opportunity to come in and talk to all of you today, at least virtually. So we'll just go ahead and jump in. We understand there's a lot of content, and just in general, we're going to start out with the iceberg because there's two reasons this iceberg is relevant here, and that's why we're starting our presentation here. First, as you can imagine from Ella and Seth's introduction, IP covers a lot of different topics, and we're going to touch on a lot of different topics today. Each one of those topics we could spend several hours talking about, and we just don't have that time, and you probably don't have the energy to listen to us talk for hours on each of those. So what we're going to do today is touch the tip of the iceberg. Please understand there's a lot of detail below the surface. If there's anything of particular interest to you, we're happy to talk to you either in the Q&A section or even just later at another time about your specific situation. But this presentation is intended to get you thinking, talk about from strategic perspective some of the issues that come up in your situations. But please understand we're not able to get into the weeds on everything. Second reason that we like this iceberg to start off the conversation is because IP and you know, as you proceed through your innovative entree into the market, IP is fraught with peril, and it's kind of like the Titanic going through the Arctic. You know what you know, but you don't always know what you don't know and what's under the surface, and things aren't always as they seem. So what we're going to try and do today is shed some light on some of those issues and at least, like I said, get you thinking. So at the outset, since we know that people here have a varying level of experience, as Seth mentioned, we're going to start off with a bit of a background to get everyone up to speed on the different types of IP, what some of the reasons are where you might choose one type of IP over another for your particular purpose, those types of IP that are particularly relevant to deep tech. And then we'll also discuss some current trends in the industry, strategic issues, as you incorporate IP into your overall business strategy. So at the outset, why have intellectual property? There's a lot of different reasons that companies and investors want to see IP in your business portfolio. Certainly for companies who wish to put a product on the market, you want to be able to protect your ideas. You want to establish your competitive edge. What makes you different in the marketplace? You do want to be able to share freely with investors what your plans are, but at the same time, protect what you've come up with. And intellectual property is one way where you can put a gate around what you have, but still be able to share it. And so that promoting investments, encouraging disclosure is one of the roles of IP. And then also, you want to understand the distinctions between different products and services and help the public. Intellectual property at the end of the day is helping you as the innovator, but then also helping the public determine what is legitimate, how things work, how it might fit into their systems. For startups in particular, IP is, it plays an important role, but it's also part of a bigger picture. And one of the questions we often get from startups is, you know, how do I know what to focus on? I have a limited budget. Maybe I'm at a seed stage. Maybe I've already gotten my Series A funding, but I'm still, you know, very attuned to, I need to protect my innovation, but at the same time, I need to pay my employees and I need to do R&D, and I don't want to put so much budget into the IP budget that I then can't generate what we need to protect in the first place. And so there's a lot of balancing, particularly at the startup stage. And depending on where you are on that startup timeline, you know, survival and growth at the beginning. I mean, honestly, this is a business, right? So you're looking for how IP can be used to help you survive, to grow your company, and proceed with whatever your end strategy is, whether it's, in 10 years, I'd like to be able to sell my company, or I want to become a name brand company within the marketplace, or even I just want to be a niche company. There's different strategies for IP depending on where you ultimately want to go with your business plan. The two areas that we typically look at in coming up with an IP strategy for any company, how can IP help you protect your technology and your innovation? But then also from a defensive perspective, what is your freedom to operate? You want to go into a particular area. Well, what about the IP that other people or other companies hold? And what does that competitive landscape look like? Is your commercial field crowded, or is it wide open? Do you have a lot of opportunity to stake out a wide claim, or is your footprint going to be really small? So we call that freedom to operate, looking at the competitive landscape. It's kind of the flip side. That's where we look at other people's IP and see where our opportunities are. And then we consider our innovation as the IP protection. How do we protect our fundamental platforms that can keep our competitors out of our guarded area? There are 4 primary categories of intellectual property. The one that people are commonly familiar with, patents. Patents protect the fundamental concept of an idea. So these are processes, machines, manufacturers, compositions of matter. Those are considered kind of the 4 fundamental categories of creations that are innovative. In the software space and the deep tech space, sometimes these are the algorithms that are underscoring your competitive advantage, why you can get to a 97% accuracy rate instead of a 90% accuracy rate. How do you, how do you overcome some of the technical problems that have limited other people in the industry? Trademarks and service marks are how a company is branded to the public. How does the public identify you as a company? What is your branding associated with? So like Coca-Cola, it's a trademark, it's very well known. Service marks as well, if you have a company that's providing a particular service and they're known by it. So these are kind of like the public-facing brand information, slogans, logos, things like that. Copyrights are where you have an actual expression, like books, music, so sheet music, audible recordings can be copyrighted. Software can actually be copyrighted. You can copyright the code. You can also, it doesn't have to be down at the assembly level. It can be pseudocode that you copyright. But that's typically focused on the actual implementation as opposed to the idea as a whole. Trade secrets are also very important in deep tech. Trade secrets are the information that is, as is its name, it's secret to your company. It gives you a competitive advantage. And if that information became publicly known, then your competitors might be able to take some of your market cap or some of your strategic information, whether that be client lists or the fundamental way that you're performing a particular process. All of these are considered intellectual property. They are intended to be complementary to each other. There's, when you're putting a product on the market, for example, you're probably going to have each one of these in some respect, or at least want to consider each one of these. And so they're intended to work together, and they just cover sort of different flavors of your innovation. In deep tech in particular, and so if we're looking at computational methods, software, informatics, analytics, that sort of thing, patents and trade secrets are really the ones that you're looking at. Trademarks, that's the branding, that's not specific, you probably use it in a deep tech company, but probably not specific to your innovation. Copyright, you can copyright code, but that's very specific to just that one implementation. So we look at patents because that is what protects the fundamental concept of the innovation. You might implement it in different ways, but if you're getting to an end result by a particular process, there may be some distinctions in implementation, but the overall idea is what you're trying to patent. And then trade secrets, particularly with deep tech, trade secrets are really important because there's a question of how do you even know what somebody else is doing? How does somebody know what you're doing? If I have a machine learning algorithm or if I have a neural network, sometimes it goes into a black box. And is that something I can keep secret? Or by putting my product on the market, is it something that other people can figure out how I did it or reverse engineer? So I'd like to talk about trade secrets first. Back up a second. Most of this presentation will focus on trade secrets and patents as being the IP. A lot of the presentation is more strategic in nature, which we'll get into, but when we talk about protection and developing a strategy, patents and trademarks in deep tech are the primary methods by which we do that. But I start with trade secrets because at the outset, everything you come up with is at the very beginning a trade secret. If you're working with one of your colleagues at your company and you come up with an idea, just the two of you know about it, before you've announced it, before you've shared it, before you've implemented it, it's a secret between you. A trade secret is something that the public doesn't generally know, and it gives the holder some sort of a competitive advantage. There are certainly secrets that offer no business advantage. They're not really considered trade secrets. They might be secrets, they're not trade secrets. To really be a trade secret, it has to, one, be a secret, two, have commercial value, that's the business aspect, the trade aspect of it, and then it not generally be known or ascertained. So if I have a particular software tool and I send the source code for that out, and somebody can reverse engineer it. I have a front-facing interface, but somebody can get in and reverse engineer that software tool, then it can probably be somewhat easily ascertained. So probably not a trade secret. So you have to not only have it secret, but you have to be able to keep it secret from others who are trying to reverse engineer. A trade secret is good for as long as it's kept secret. When the secret is disclosed, it's not a secret anymore. Your trade secret protection, if it's disclosed, of course, by you, your trade secret protection expires if it's made generally public. You've lost your trade secret. Some examples of things that are trade secrets, particularly in the deep tech space, your source code, particularly if you don't have a public-facing portion of a software tool, software program, neural networks, for example. You might output the result, and you might be in the business of, analyzing data, producing a result, but how you actually analyze that data is removed from the public interface. Or sometimes you have both public interfaces and then your back-end tools. So source code, algorithms, formulas for particular materials can be considered trade secrets. Test results, including your unsuccessful tests. Sometimes, if you're in the bioinformatics space, for example, and you're testing out a new diagnostic drug, and you're trying to figure out what combination of materials is, best suited for a particular, genetic class of people, knowing what the unsuccessful tests are can be very valuable because you've gone that direction. And it hasn't worked. So you've been able to narrow down the path. Manufacturing processes, customer data, supplier lists, purchasing information, how much you pay for one of your supplies is actually really good trade information if you have a good deal set up with your supplier. So these are all types of things that are considered trade secrets in general. A patent, on the flip side, is essentially it's an exclusionary right. A lot of people have a misconception about patents, and I hear it especially from folks who are new to IP. They have an idea that, okay, if I get a patent on my idea, now I can go out and market my product. But really what a patent does is if you get a patent on your idea, it prevents other people from marketing your product. By marketing your product, you might actually run into other people's patents. If I have a patent on, a chair with 4 wheels, and I want to market that, I might be able to get a patent on a chair with 4 wheels, but someone else might have a patent on a chair with arms. And so I might, even though my 4 wheels might be new, I might still run into somebody else's patent from other aspects of it. So a patent prevents others from doing what you've claimed as your patent. And it's essentially a negotiation. You agree to disclose how you did, how you implemented your invention, how you created it. One of the requirements is that a person with skill in the field can make and use the invention just based on what you've disclosed in your patent. So they have to be able to copy it, and it has to be able to work, within reason. But in exchange for that, you're given this limited monopoly. And so it's just, a patent doesn't give you the right to use it, but it at least prevents others from doing it if that's your competitive edge. And I'll turn it over to Gaby from here to talk about some of the advantages of patents and disadvantages and how you choose between some of these.
Thanks, Michelle. And hi, everyone. So advantages of patents, of course, a lot of these advantages you probably already have heard of or know about. First of all, it's an advantage to the public when people disclose their patents, because the idea being that if the patent is disclosed, the next level of innovation will sort of build off of that, which is good for the public. And then you sort of project from there and go up and to the next invention, and then that's disclosed, and then you sort of build on each idea. It also encourages investment. A lot of investors, we see this when we deal with our clients and they have investors looking at what they have. They want to see some sort of IP, whether it's patents or something else. And typically just even having a provisional patent application, and we'll talk about the different types of patents, but even just having a provisional patent application is sometimes enough for a VC or some other investor to invest in a company. So it's usually hugely important in terms of investment because it provides a barrier to entry. So if there's a patent there, someone can't just go and copy the innovation and just go market it. They have to either come to you to get a license or at least talk about it, or you can sell the patent. It gives you a lot of different options. Also, if you have a patent, someone can't use your invention as a trade secret, because if you don't disclose it and they just happen to figure it out, you can't really go after them because they have figured it out on their own and they're keeping it trade secret. So it's another way of getting some value to the company. I mentioned cross-licensing, but cross-licensing is another way where sort of what Michelle just said, that just because you have a patent on a chair doesn't mean you could just go and make this chair. There may be other things that are blocking you. In my world, I'm in biopharma and chemicals. So, for example, if there is a patent on when aspirin was first discovered, say, of course now it's found in nature, but if aspirin was patented and you came up with a method of using aspirin, you can't just go and market that because somebody holds the patent on aspirin. You have to go and talk to them. So you may want to cross-license. And then a lot of this, of course, is very expensive. A lot of this research is very expensive. R&D is very expensive. So this is a way to recoup some, at least part of your dollars that you spend trying to get this innovation going and having a patent to show for, so to speak. On the flip side, disadvantages of patents. So one is that you do have to publicly disclose your invention, and you have to give enough information in your patent that enables someone else to make your invention. Now, you do exclude them from doing it for 17 or 20 years, but after that, they can go ahead and tweak it. Even before 20 years, they can tweak it and get around your patent. Once they know what you have, they can improve on something. They can patent, let's say it's a process of purifying a chemical. They can come up with a new way of purifying that chemical that's different from yours and get a patent based on what you taught them. So that is one disadvantage. And like I said, it's typically now 20 years from filing is the protection that you receive for most patents. So it is somewhat limited, right? A trade secret is forever, patent is for about 20 years. Typically, if you want to or go for a patent, you don't just get a patent in the US. You want to get patents at least in Europe, Japan, some of the countries that investors are typically looking for. And of course, once it's public in one country, it's public everywhere else. And in some technology areas, the patent may only be valuable for 2 years, 3 years. It may cost you a lot of money, and maybe it's only going to give you a benefit for 3 years. This is, of course, different in my area because in biotech, as you know, developing, and let's say a Humira, an antibody, takes many, many years, gobs of money. I mean, we're talking over $100 million. So you want a patent to last for a good 20 years because it takes so long to even develop a product. So the technology doesn't quickly evolve typically in the biotech space, but in other areas it does. So that's why some of these strategies are so dependent on the area you're in and the technology. Bio, chem, pharma, you want fewer patents with long terms and different layers of patents. Sometimes I hear on the technology side, you have something on a new iPhone, it's 2 years, and then we're moving on to the next one. So it all depends. Next slide. Thanks. So just to quickly recap on the differences between trade secret and patent, how would you choose? What should I do? Should I get a patent? Should I keep it a trade secret or not? We highlighted some of the differences. Typically for trade secrets in my world, it's my first question to the inventors is, well, how long did it take you to come up with this? And how long do you think your competitor, how long would it take them to come up with it? So just as an example, let's say it's for a probiotic. It's something that has to be cultured with these huge fermenters, and it took them a while, but it took them 3 years to come up with the perfect way to produce this probiotic. And a competitor, may have a few more difficulties finding the right people. It may take them 5 years. Well, then you're thinking, okay, 5 years until someone can figure it out if you kept it as a trade secret versus 20 years of patent protection. So the question usually is, can somebody back engineer it? And there's a lot of ways to do that. So if there's any chance that someone can arrive and reverse engineer and get back at your invention, then you probably want a patent. Of course, there's other considerations, but that's sort of usually the main one.
JB, if I can just jump in with a comment, particularly in the deep learning area, we think about a lot of these algorithms, and if you're using, some kind of supervised or certainly with unsupervised learning, you don't necessarily know what's happening. How are you getting to this result in the first place? That's currently a lot of the situation. We don't yet, I don't think, have reached the level of explainable AI, for example, to know really what's happening in a lot of these processes. But when we think about patents, this 20-year term is important because we have to think about, well, what about for the next 20 years? Things that are considered more likely to be a trade secret right now because I don't even know how the algorithm is getting to this result. I'm sure nobody else can figure that out. Or I have everything encrypted and it's pretty much unbreakable encryption. I mean, 10 years ago, there was 128-bit encryption, probably unbreakable. Now there are computers that can actually get in and decrypt what was previously thought to be unbreakable encryption. And so when you're trying to decide between trade secret and patents, particularly in the algorithmic space, it requires a little bit of crystal ball gazing. What do you think is likely to happen in 10, 15 years? How long can you really keep this a secret? If you can keep it almost to the length of a patent, or you don't think the technology is going to be moving fast enough for your algorithm to be reverse engineered, then that might be a benefit for trade secret because you can keep it even longer. But if you think where the industry is going, we're getting to explainable AI. It's just an example. I don't think we're getting there not quite that fast. But if we're getting there in a couple of years, then that might be way differently.
Thanks, Michelle. Good points. that's another point here, that we're not trying to say that you would choose also trade secret or patent. A lot of times companies have a mix of both. In fact, you probably want to have a mix of both if you can. And where this happens more, in my area, where this happens a lot is when it's a biologic. Biologics are very complicated, large proteins with lots of things going on, and the manufacturing methods are extremely complicated. You have to actually culture these things in mammalian cells or bacterial cells or yeast cells or some other cell. You have to figure out the growth conditions, the temperature, the growth media. All of that is sort of trial and error sometimes. And then once you arrive at that, you want to keep that a trade secret because it's extremely difficult to copy that and to come up with the exact same mechanism. And also, the way things currently stand for biologics in the US, for a competitor to make the same biologic, sort of a generic version of it, they have to almost copy your process verbatim to be able to get the same product out of the cells. So you don't want to disclose all of your secrets, but you do want to get some patents around the big sort of concepts of culturing and whatever, but not the nitty gritty, little gold nuggets that took you a long time to arrive at. Just to finish up on this slide, patents have a presumption of validity, but they are expensive. You got to file it, prepare it, prosecute it, file it worldwide. You have to register it. You have to pay maintenance fees. You have to meet all these various requirements. Whereas a trade secret is pretty much, no registration, no application, no real cost. However, I should add in the days of COVID, with everybody working remotely and everything is electronic, just think about the chances of some trade secret getting out almost easier now than perhaps before. And also with a lot of employees leaving a company, going somewhere else, you have to have processes in place to make sure that you record somewhere what the trade secret is and keep that under lock and key. But if you're one employee, there's this one employee who knows how to do this, and that person leaves, there goes your trade secret's kind of at risk. So those are sort of the considerations between trade secret and patent. So then, deciding whether to file a patent, I think we talked a little bit about that already, and it all really comes down to what is your IP strategy, what is it that you're trying to get out of your company and your IP, And IP, again, it's not just patents and it's not just trade secrets. It's also copyrights, it's trademarks, it's trade dress, it's your know-how. All of that together adds value to your company. So depending on whenever Don, Michelle, or I get a new client in the door, we sit down with them to really understand what is your business, where are you trying to go, what kind of IP are you hoping to get, what will you do with it. And sometimes it's defensive, sometimes it's, we really don't want to patent what we have. We just want to make sure that others don't do this and block us. So we just want to get some defensive IP. We can do that. Or you want to get IP that you want to sell or license, we can do that. Sometimes there's some bet the company stuff that we have to get. And that's where we're going to spend all the resources on. And then we have some other little things that we also want to get, but we don't want to spend a lot of money on. So all of that goes sort of into the equation of trying to develop somebody's IP strategy. And of course, for startups, it's so important to know how to invest and where to invest, because you don't have gobs of money lying around, but you still need IP. So it's really super important to come up with a strategy early on so that you know exactly what you're going to be spending money on and what you're going to try to get. I get some startups sometimes that have so many ideas and they're talking 10 different patent applications. Well, I'm sorry, you don't have the budget for 10 patent applications. Let's talk about what you really need, and maybe we can get this patent first because you have the idea of licensing this out. That will get you some revenue, and then maybe we can do the other things, or we can at least file provisionals so you have something there, and then you have a year to try and get some investors interested, etc. So really important to invest strategically, figure out what's important to you, what is the invention about? What parts do we need to keep secret or not? Getting a patent, a lot of times, is not difficult. Getting a good patent is a whole nother story. So, coming up with a patent that has, 10 different claim limitations in claim 1, well, how are you going to demonstrate infringement? Or how are you going to, especially if there are claims in the patent that talk about processes that happen in the body. Well, how are you going to demonstrate infringement? Does that make a lot of sense? So there's just a lot that goes into what you're going to claim and how you're going to claim it and what's going to actually add value. Is it just getting patents to add value? Fine. But if it's really getting strategic patents, that's a whole nother ballgame.
And one of the things, just to add, that you have to look at it, and this is what you expect your competitors do. If you have an end-to-end process, for each step of that process, there may be multiple ways to perform that process. But to get to the end, maybe you have to converge for one step. There's really only one way to do it. If they're going to get to this end result, they have to perform this one step. There's options for things around that, but they have to perform that one. That's probably where you want to look at. Where are your competitors going to have to come into your space if they want to compete with you? Versus where are there just general options that they could design around, say, your patent application or your patent very easily. So looking at what your competitors are likely to have to do to catch up with you is a big part of that strategic investment.
Gaby, if you can go back to that slide. Sorry, Ella here. Can you elaborate on the second point here? Is the invention technological or entrepreneurial? Like what exactly do you mean by that?
That's a good question. Of course, technological, the way I'm looking at it, is some hardcore, say, chemistry patent. How to make this particular chemical compound, as an example. Whereas entrepreneurial could be more like a business method patent, procedure, or one of the REMS types patents. The REMS types patents are where, for a pregnant woman to get a certain medication, first she has to get this test done that demonstrates she's not pregnant, then she goes to the pharmacy and then gets it. So it's a little bit more of a networking, broader scope of patent, rather than sort of what I think about as a hardcore technology patent. Michelle, you want to add on to that?
Yeah, and because I think that one of the other places, particularly for the deep tech and AI space, that this comes in a lot of countries in the world, if you have a software application, they look to see whether or not your software is a technical solution to a technical problem. The US phrases it a little bit differently, but it's essentially the same kind of analysis. So if you're trying to get a patent, you have to be able to show that you're solving, in most cases, a technical problem, as opposed to a business problem. Gaby mentioned business methods. What does that really mean? It means that I have a problem with my business. I'm trying to figure out a better way to get in touch with my with my partners or with my customers. And I figured out if I contact them on Tuesdays at 10 o'clock, that's really the best time. That's really a business issue. It's not a technological issue. And so for a lot of the major patent offices in the world, they want to see that you're solving a problem with technology. How technology is defined, that's a wishy-washy term. It can be a variety of things, but that's really what it's looking at, just to distinguish it from, is this a problem that I came up with because it was really kind of bad for business, or is there something technical behind it? And it's, particularly in the software space, you have software that can solve all kinds of problems. What is your problem that it's trying to solve?
I think I'm going to turn it over to Dawn now.
Thanks, Gaby, and thanks to the 50 Years team for inviting us all. Hi, everyone. All right, let's get into a little bit of the guts of the patent itself. And later on in the second half, we'll talk a little bit more about the strategies and a lot of things that Gaby and Michelle have already talked about with you, but kind of the timing of it and how we implement some of that stuff as well. So So what is it? What can be patented? Well, first of all, we have to look at the eligibility under the statute, and we call this statutory subject matter, and I'll get into that a bit in a couple slides. It also has to be something that's new, something that's unobvious, and also it has to have utility, right? And this is all measured against what we call the prior art, which is all of that technology that has come before. And from a timing perspective, we'll get into that a little bit too. So here we have 35 United States Code 101. And this sets forth what can be patented generally, like we just talked about. And here we have, for example, new and useful processes, machines, manufacturers, or compositions of matter. Improvements thereof are the things that constitute those things that can be patented. Let's see here. Types of patents. So we have utility patents, which are the typical patents when somebody says, "Oh, I've got a patent." These are usually the patents that we're referring to. As Gaby mentioned, there was the American Invents Act back in 2013 that changed. Pardon me. Back in 1995, we went from a 17-year patent term to a 20-year patent term. So that's something important here. And the utility patent, again, goes to a functionality of the invention versus we talked about trademarks and trade secrets distinctions between the functionality of a patent. Design patent is another animal too. That is basically goes the ornamentation, not the functionality of the patent. They have 14-year terms as well, but they do also have to be novel and unobvious. Maybe Gaby, real quick, you can talk about planned patent. I know there are a couple on the wall behind you there.
Yes. Planned patents are really cool. They only have one claim, and they have color photos, and they are the most gorgeous photos of new plants that you can get. You can also get plant certificates, but planned patents are also 20-year term. I got one of these at a presentation where I was a panelist, and I thought it was so cool. It's these are really old from 1940s, and the back of it is the planned patent. I got one, and I got two more to match them because I thought it was such a cool gift.
All right, so let's first focus on a little bit more about the utility patents. Michelle, if you could just go to the next slide. We have in the U.S. two different types of patent applications. You've heard of provisional patent applications and non-provisional patent applications. The provisional patent application does not get examined in the U.S. It provides you basically a 1-year period to make some maybe business decisions, or if your invention is kind of in flux and it's still being developed, you can file a series of provisional applications that will claim priority back to the original provisional patent application. So within that one-year priority application, you just have to get all your ducks in a row and then put together your final non-provisional patent application that needs to be filed within 1 year of the initial filing date of your provisional application. That non-provisional application then does get examined, and we'll get into a little bit more information about that. Internationally, here we have a little map of the globe, this is thanks to the World Intellectual Property Organization, or WIPO, and this really, all the blue here illustrates all the 153 countries around the world that are signatories to something that's called the Patent Cooperation Treaty. I think, Seth, you mentioned you actually heard of a PCT before. Anyhow, this is a process that is international, allows you to file one patent application that then can be entered into all national stage processing in all these 153 patent applications or countries, but that gets very, very expensive. So the PCT allows you to kind of stretch things out for at least 30 months to make a determination as to whether you want to pay all the fees to get direct examination in these different countries. So it's just another mechanism kind of to get the ball rolling with regard to a full non-provisional patent application internationally. Another animal is called a utility model. This is really only used in some countries. It's only provides a limited amount of protection. It goes through limited amount of examination. It's not as rigorous examination, and it's only in a couple countries throughout the world as well. But it is available. So here we have kind of a comparison of what could be protected under a utility patent. We've already talked about the machine or processes, also called methods. They can be methods of manufacturing and methods of use, but they're all processes under the statute. And chemicals, articles of manufacturing. Some of the things that we can't patent are abstract ideas, mathematical equations, and laws of nature, natural phenomena. Now, Michelle will kind of get into some of the and articulate some of the how those kind of overlap with why we have here in the slide. Sometimes we can patent some software, sometimes we can't. Sometimes you can patent a business method or method of doing business. Sometimes you can't. And it does turn typically on articulating a technical problem to be addressed and a technical solution to that technical problem. And again, Michelle will get to that in the latter half of our presentation after break.
Yeah, although I will just add that it doesn't help that at least the United States Patent Office keeps changing its rules on this about every couple of years. So
yeah, it is very troubling. I just had a PNC last week, and this week I had to basically explain that this is what it would probably cost to file a business method patent application for you, but we're happy to spend a couple hours with you, as a courtesy without billing you to kind of figure out if this is something that we really think you can patent or not patent. And then we can talk about, open the kimono and you can explain to us all the guts of your business method and then we can work on a patent application with you. But it has been a moving target in the U.S. for quite a long time. And again, we'll get to that a bit later. So the parts of the patent, basically we just threw these up here. There's the abstract, the specification, which we also call the detailed description. Figures, if the invention lends itself to being illustrated in figures, and the claims. The claims are this archaic patentees that are these long run-on sentences at the end of the patent, which I'll get into in a minute. All right, the specification. I know this is hard to see. Perhaps you've seen a patent application before, but the patent application, the specification has the claims are at the end, but the written description part, these words you see here, it starts out with a background of the invention section. Essentially what you're trying to do is you're trying to set up the 10 soldiers that you want to shoot down and explain why your invention is important compared to what happened before. So the background usually sets forth the problem that the inventors are looking to solve. Sometimes we want to talk about in the background section how others have tried to address that solution before, what some of the shortcomings of those solutions are. That's the background section. We usually have a summary section which kind of takes that arcane set of claims we have at the end and it kind of breaks it down in some short declarative English sentences that explain a little more basic. One of the things that we like to try to do in the patent specification is tell a story, because the patent is going to be a living business document that, first off, we have to be able to explain the invention so the business folks in the company understand what's going on. When you go out to get an investment, you need to be able to show this document to people who aren't as technical savvy as the patent attorney that wrote it, or the examiner that's going to examine it, or the inventors themselves. So you have to abstract it to a level so that other people can understand it. If you want to go to negotiations and doing cross licensing, other business people, other lawyers that aren't patent attorneys might have to understand it as well. If you want to enforce it, right, we're going to get into the courts. We're going to have a lay judge and a lay jury trying to understand what's going on here in these deep tech AI inventions, and we need to bubble it up and really explain it in a way that non-technologists can understand it. But at the same time, we have to provide the support for the claims. So the patent application, the specification is also going to have definitions of the terms that are in the claims or terms that we might put in the claims as well. So we spend a lot of time, costs a lot of money to put these patent applications together sometimes in complex technologies. Here we have the abstract down at the lower right-hand corner here, and that's used for classification reasons at the patent office, et cetera. So Michelle, we might go on to figures. We can have block diagrams and flow charts and, screenshots, mechanical perspective views and three-dimensional views of complex mechanical inventions as well, and those sorts of things. Gaby, how often do you include figures in your biotech invention?
I would say almost every time. Yeah, we don't have a ton of figures, but it's we typically have data actually. Rather than sort of drawings, we have, Western blots and DNA sequences and a bunch of other type of data, and then comparison graphs, placebo versus this treatment, showing that kind of thing. But yeah, we almost always have figures.
Chemical cases, you always have the chemical structures themselves and all the different embodiments of the chemical structures and what compounds can be placed in, and
Yeah, XRPD, DSC, for those of you who are familiar with chemical compounds, all of TGA, we always show all of that. Yeah.
And then we come to the claims. Again, these are numbered paragraphs, so these run-on sentences at the end of the application. And this, if you think about the land rush, when all the land was opened up out west in the United States, and people would go out and stake their claim. They put their stick in the ground, and they were given a certain amount of property that they can claim as theirs, and eventually they'd put up a fence around that property. Well, that's what these claims are. These claims, in words, have to distinguish the invention from what's gone before, the prior art, like we talked about, and that's what the claim is. Next slide. About what you can claim. It's not necessarily the product that you want to claim, but sometimes we do include what are called picture claims, which in essence are the product. How the invention distinguishes itself from the prior art is what we really like to try to focus on. We also want to focus the claims on how we're going to go after infringers. Who's going to infringe this type of claim? What is this invention about, right? Is there a reseller, a manufacturer, the chain of production and sales and all sorts of things like that. Intermediary products of during the manufacturing process as well. One thing we have to worry about is something called divided infringement, right? We don't want claims where we've got one entity that is going to have to perform one aspect of the claim and another entity the other aspect of the claim. Just to make it simple, if we're claiming a communication system, right, and we've got a transmitter and a receiver, but only one party is going to use the transmitter and the other party the receiver, you want to be careful in your system claim how you claim that. This is an invention here of actually a photolithography invention. We've got the light source number 2 over at the end. We've got a semiconductor wafer W at the bottom. We've got the pattern number 11 there that we want to project down on the wafer, and then a processing unit there that runs the whole thing. And so there are a lot of different things here to claim: the optics, the light source, the final product, the wafer itself, the software and the computer system we might want to file patent applications on, the methods of manufacturing, all those sort of things that were involved basically in summarized in one figure here. But we need to think about all that and describe all that in the patent application, have figures to all that in the patent applications, and then claim all these various things. And when we file the patent application, we could have, claimed all these different inventions in there. When we get to file the patent application, Gabe will talk about this a little bit later, we're probably going to be limited to talk about, one invention at a time. We can describe many inventions in a single patent application. But when we're going through the examination process, we really only examine one invention at a time. Gaby, I think you're up here.
Yes, thank you, Don. So you have your patent application prepared and you filed it. And depending on if you filed it as a track 1, which is sort of a rapid action version, or a regular application, you'll get an office action either within 3 months or within, say, a year and a half or so. So it really depends on how fast do you want this patent. That determines how you file it. You get assigned a patent examiner. As Don mentioned, based on the abstract, they sort of classified at the PTO in a particular class and subclass, which, let's say subclass, class 1600, which is one where, or ART unit 1600, which is where a lot of biotech applications are examined. And getting assigned to a patent examiner, that alone is probably a whole nother hour discussion, but it can make or break your patent. Which is really sad, but it really is true that depending on the examiner you get, you may get very easy prosecution or you may go nowhere. There are actually companies that all they do is collect stats on examiners, so that as soon as you get an examiner assigned to your case, you can go look up how many times does this examiner allow the case within a year or 2 years. Does an interview help or not help? How many times do I have to appeal the case with this examiner and all of that? And our actual strategy, prosecution strategy, will sort of keep this in mind. It really makes a huge difference knowing all of this about your examiner. The examiner will look at the claims, as Don mentioned, in view of not just the prior art, which is, what was already known before you filed this patent application. Are these claims novel? Are they non-obvious? Or are they both? But also, do you have enough description in your patent application to make sure that this invention is enabled? Someone can actually look at it and actually arrive at what you're trying to claim. And is it actually described in such a way that it made it clear to the public that you had possession, what we call possession of this invention? I think we're going to get to questions later, but I saw something flash up about how much do you put in the application? Well, it depends. Everything always depends. But for biotech applications, we put a lot of information because you have to have, a lot of times there's sort of a genus of, say, different receptors, chimeric receptors claimed. You have to have enough species of receptors disclosed in your spec to be able to enable that big genus of receptors. I hope that makes sense.
If I could jump in, Gaby, I'd say it's a sliding scale.
Yeah.
There are the predictable arts like mechanical and some electrical arts. Then you get into chemistry and biotechnology, right? So less disclosure on the predictable arts, a lot more disclosure on the non-predictable arts.
Exactly. Yep.
Again, because you have to be in possession of the invention.
Exactly. Yep. Excellent point. And then hopefully within a reasonable amount of time, typically about 3 years, if it's a regularly filed application, less than a year, if it's a track 1 or fast track examination, you hopefully get the patent allowed. And just a little tidbit, a lot of times people talk about their patents. I filed patents and, I have patents and it turns out they're actually patent applications. So be careful that if it's just a filed application that's still pending, that is not a patent. It's just a patent application. Until it's allowed and issued, you don't have the patent yet. So, but once you get those claims allowed and the patent issues, then you get your maintenance fees that you have to pay these various years. If you don't pay the maintenance fees, then the patent just goes abandoned, basically. And then anybody can just practice whatever you were trying to exclude them from. So this is a very high level overview because as Michelle said at the beginning, we can go just the subject of prosecution and examination to PTO is like a whole day of discussion about strategy and all kinds of things. Filing and prosecutions is very quickly life of patent, and I know it looks kind of complicated, but it's not. You start on the left. We talked about this left part already, this left column about the invention. Should I keep it a secret or not? Should I patent it? If you do decide to patent it, then that 0 time point, that NP0, that's your first filed case, whether it's a provisional or a non-provisional. If you want to get a patent quickly, you typically file as a non-provisional, so it's immediately examined. If you want to buy more time, you just want to get the date secured, then you would typically file a provisional, which is not examined. You just file it, it gets the date, and it just sits there for a year until you have to convert it to a non-provisional. If you file a provisional, typically 1 year later, you must do something with it or it goes abandoned. So you then either file your non-provisional and the PCT that Don talked about, which is what's going to get you worldwide protection. Or if you have non-provisional filed on your 0 time point, then a year later you would still file your PCT filing. Once you file that PCT, 30 months from the first filing date, so 30 months from the initial date that you got, you have to decide, am I going to go worldwide? Am I going to go into all these different countries that are a part of the PCT? If there are countries that are not part of the PCT, you have to file in those countries right away, at the same time you file that PCT. And there's certain countries, like the smaller countries in South America that I'm familiar with, like, Uruguay, Paraguay, Bolivia. Some of these countries are not part of PCT, so you have to file directly in those countries. And then all of those numbers there, like NP 01, 02, 03, those are designate different countries. So national phase, what we call the national phase filing. So you have one for Europe, for Japan, South Korea, Australia, Canada, Brazil, whatever countries. There's a lot of countries to choose from, and just choosing the countries and knowing what each country is known for, or whether you'll be able to enforce your invention in those countries, that's a whole nother 5-hour discussion. But then you get the national stage. Each country will have their own patent office and their own examiners. Hungary will have their own ways of doing things. Israel will have their other way, Norway, whatever. They will each examine, and they all have different rules. South Africa, they don't really examine. They just stamp it and you get your patent. This is different from, say, Japan. That is very strict. And, you go through a lot of rounds sometimes of prosecution. But eventually you'll get these granted. Then you also have maintenance fees for all of these patents. Actually, before, during the prosecution, you have different fees. And then you get, hopefully, patents in these various countries. And all of that, constitutes your global IP portfolio. I've been told, just as an anecdote, one of my clients at some point said, should we file this in China? I don't know. People are telling me it's just kind of a waste to file in China. You can't enforce it. And, should we really do it? And we convinced them that they should do it. And it turned out about a couple years later, they had interest from a Chinese investor that wanted to invest and market their product in China. And they wanted to see a patent application in China. If they didn't have that patent application in China, they were not interested. So you just never know. And sometimes it's worth that expense because you just don't know what people are going to be looking at. So things to keep in mind. You have to be really careful what you publicly disclose, as you probably already know. We do have a grace period in the US, but a lot of countries do not have a grace period. So even if you published that abstract or you had that talk at that conference the day before, that may block you. So it's very painful to lose out on something like that. So you have to have processes in place to make sure that you get something on file before it's publicly disclosed, even though you have that grace period in the US, because you may get hurt in other countries. You can't just pick and choose what you want to disclose. If you know a way of making this chemical compound, you better have that disclosed, because that is your best mode. And that is a requirement by statute. Nobody can quite attack you that way, but anymore, because of the AIA and the way the rules changed. But I can imagine that there could just still be some sort of inequitable conduct argument made that you knew, further down in litigation, this may come out that you knew of the best way to make it. You didn't disclose it to the public. So it can come back to haunt you. You don't have to actually make the invention in the US and most countries, but you do have to show or know how you would make it. You can have prophetic examples, and you can provide data after filing in the US where you say, well, this is how I predicted, right? A prophetic example, you haven't actually done it, but this, if I had done it, here's the data that demonstrates that what I said in my application was correct. You can't do this in all countries, but you can do it in the US. Different countries have different requirements, as I said, and different technologies, different strategies, as mechanical arts, predictable versus the unpredictable biotech arts. Utility patents, I think I talked about this already, right? Publication before filing, be really careful. If you use it in public before filing, can be a problem. If you offer for sale, you have to be really careful how you draft some of these contracts. Just depending on how you word it, could suggest that it was a sale versus just a experimental use. So that becomes hugely important. And by others, so it's by the inventor versus by others, similar considerations. We just wanted to put in this slide about ownership. Sometimes that comes up, who is an inventor and who's an owner, and how is this the same or different? It depends. Typically employees get employment agreements that they need to sign, and they must, assign their rights to whatever they invent to their employer. Consultants typically have agreements, contractors, they're software developers. If there's government funding, the government may have, margin rights at some point. So you have to be aware of all that. If it's a university, they have very specific and rigid rules sometimes. So again, this topic is a very big topic, but we just wanted to make the point that you understand that there's a difference between inventorship and ownership. And that they're not always the same, and sometimes there's multiple owners. There could be they're joint research agreements where you have different inventors from different companies coming together, and it can get pretty complicated.
And particularly with startups, that's something to keep in mind, because startups often don't necessarily have in their employment agreements, especially if it's just a small group of people that are friends doing a startup, they may not have in their employment agreement who owns the IP, or that IP automatically transfers. And sometimes, it's folks who are doing startups because it's a spin-off out of a university lab, for example, and the university may have some rights. And so it's just important to keep in mind that there has to be some transfer of that intellectual property to the startup, to the company. Otherwise, it, at least in the United States, if that's where the invention occurs, it rests with the inventors or any other party who has some interest in those rights. And I think with that, I know that was a lot in a short amount of time, but I think, I recognize we want to go ahead and take a break before we get into the next section.